Picture this. Your business partner decides to rewrite the rules of the game without telling you. You're talking serious breach of contract stuff. Your first instinct might be, I'll see them in court. And while that's certainly an option, there's a less chaotic, more civilized alternative: arbitration. Think of it as dispute resolution for the rest of us. It's a way to settle disagreements outside the public eye of a courtroom, without the drama, the jury of your potentially very confused peers, and the seemingly endless delays. Arbitration is becoming increasingly common, especially in business and consumer contracts. You might be surprised to know you've probably already agreed to arbitration without even realizing it. Ever actually read the terms and conditions before clicking agree? Yeah, me neither. But hidden in those walls of text, there's often a clause stating that any disputes will be settled through arbitration, not a court case. Now, I know what you're thinking. John, this sounds suspiciously like something rich corporations came up with to screw over the little guy. And you wouldn't be entirely wrong to be suspicious. But stick with me. Because while the system isn't perfect, arbitration can offer some surprising advantages for everyone involved. It can be faster, cheaper, and more flexible than traditional litigation. Plus, it keeps your dirty laundry out of the public eye, which is always a bonus, right? So let's delve into the world of arbitration and see if it's the right fit for your potential legal battles. In the simplest terms, arbitration is like going to court, but instead of a judge in a black robe, you have a neutral third party called an arbitrator who listens to both sides and makes a decision. This decision is usually legally binding, meaning you have to follow it just like you would a court order. Think of it like this. Remember when you were a kid and you'd get into a fight with your sibling? Instead of your parents always taking sides or just yelling at both of you, they might have called in a neutral party, like your long-suffering babysitter, to decide who was in the wrong. Arbitration works in a similar way, but instead of arguing over who gets the last cookie, you're dealing with things like contract disputes, employment disagreements, or even international trade issues. It's a way to resolve conflicts without the cost, formality, and time commitment of a full-blown court case. And let's be honest, nobody wants to spend years of their life and their life savings battling it out in court if they can avoid it. Now you might be thinking, but John, what's to stop the arbitrator from being biased or unfair? That's a valid concern, but the good news is that there are rules and procedures in place to ensure fairness. Both parties have a say in choosing the arbitrator, and the entire process is designed to be neutral and impartial. It's like picking a referee for a football game. You want someone who knows the rules, will call a fair game, and won't be swayed by fancy footwork or loud complaining from either team. So, how does this whole arbitration thing actually work? Well, it all starts with an agreement. This usually happens in one of two ways. The first is through an arbitration clause in a contract. Remember those terms and conditions I mentioned earlier? Yeah, that's where you'll often find these sneaky little clauses. They basically say that if any disputes arise related to the contract, you agree to settle them through arbitration instead of going to court. The second way to enter into arbitration is after a dispute has already arisen. Let's say you and your neighbor are having a disagreement about a shared fence. Instead of immediately calling your lawyers and preparing for a legal showdown, you could agree to try arbitration. You'd both sign an agreement outlining the terms of the arbitration, like who pays for the arbitrator, what rules will be followed, and whether the arbitrator's decision will be binding or non-binding. Now, I know what you're thinking. John, this all sounds very formal and contractual. Can't we just settle this like adults over a cup of coffee? And while that would be lovely, the reality is that having a written agreement is crucial. It sets clear expectations for everyone involved and helps avoid misunderstandings down the line. Think of it like a prenuptial agreement for legal disputes. It's always better to have things in writing up front rather than trying to hash them out in the heat of the moment. Once you've agreed to arbitrate, the next step is choosing your arbitrator. This is a crucial decision because the arbitrator is the one who will ultimately decide the outcome of your dispute. It's like choosing your champion in a legal duel, except instead of swords and shields, they'll be armed with legal knowledge, a gavel, and, hopefully, a healthy dose of common sense. The good news is that you have some say in who gets chosen. Both parties will typically work together to select an arbitrator they feel is fair and impartial. This might involve reviewing resumes, checking references, and even conducting interviews. It's like online dating for legal disputes, except instead of swiping left or right, You're looking for someone who can objectively weigh the evidence and render a fair decision. Now, you might be thinking, John, what if we can't agree on an arbitrator? Will we be stuck in legal limbo forever? Don't worry, the system has a backup plan. If you and the other party can't agree on an arbitrator, you can use a neutral third party, like the American Arbitration Association, ASAA, or JAMS, to appoint one for you. Think of them as the legal equivalent of a dating app. But instead of setting you up on a blind date, they're providing you with a qualified and impartial arbitrator. With an arbitrator chosen, the next step is setting the stage for the main event, the arbitration hearing. This is where the preliminary hearing comes in. It's like the pre-game show before a big game, where the rules are reviewed, the players are introduced, and everyone gets mentally prepared for the action ahead. During the preliminary hearing, the arbitrator will meet with both parties and their lawyers, if they have them, to discuss the ground rules for the arbitration. This might include setting deadlines for submitting evidence, establishing procedures for witness testimony, and clarifying any procedural issues. It's like a dress rehearsal for the actual hearing, ensuring everyone is on the same page and ready to proceed. Now you might be thinking, John, this all sounds terribly formal and intimidating. Do I really need a lawyer for this? The answer, like many things in law, is it depends. While you're not required to have a lawyer for arbitration, it's often a good idea, especially if the dispute is complex or involves a significant amount of money. Think of it like this: you wouldn't perform surgery on yourself, I hope. So why would you navigate the complexities of a legal dispute without professional help? A lawyer can help you understand your rights, prepare your case, and present your arguments effectively. After the preliminary hearing comes the discovery phase, which is where things start to get interesting. This is the part of the process where both sides gather evidence to support their case. It's like a legal treasure hunt, where you're searching for documents, emails, and witness testimonies that will help convince the arbitrator that you're in the right. Discovery can involve a variety of methods, including written interrogatories, questions that the other party must answer in writing, depositions, sworn testimony given outside of court, and requests for documents. It's like building a legal fortress, brick by brick, with each piece of evidence strengthening your position. Now you might be thinking, John, this all sounds incredibly time-consuming and expensive. Isn't arbitration supposed to be faster and cheaper than going to court? And you're right, discovery can be a lengthy and costly process. However, it's important to remember that arbitration generally involves less formal discovery than traditional litigation, which can save both time and money in the long run. Plus, the discovery process is crucial for ensuring a fair and just outcome. After all, you wouldn't want the arbitrator to make a decision based on incomplete or inaccurate information, would you? Finally, after all the preparation and anticipation, it's time for the main event, the arbitration hearing. This is where both sides get to present their case to the arbitrator and make their final arguments. It's like the courtroom scene in a legal drama, but without the dramatic music, the jury box filled with judgmental stares, and the judge who looks suspiciously like your old gym teacher. The hearing itself is usually less formal than a court trial. There's no jury, and the rules of evidence are typically more relaxed. Both sides will have the opportunity to present their case, call witnesses, and cross-examine the other side's witnesses. Think of it like a structured debate, where you're trying to persuade the arbitrator that your version of events is the most accurate and compelling. Now you might be thinking, John, this all sounds incredibly nerve-wracking. What if I freeze up or say the wrong thing? It's understandable to be nervous, but remember, the arbitrator is there to listen impartially and help you reach a fair resolution. They're not there to judge you or make you feel uncomfortable. The key is to be prepared. Present your case clearly and concisely, and answer the arbitrator's questions honestly and to the best of your ability. After the hearing concludes, the arbitrator will carefully consider all the evidence and arguments presented. They'll then issue a decision, which is usually binding on both parties. This means that both sides are legally obligated to follow the arbitrator's ruling, just like they would a court order. The arbitrator's decision, also known as an award, can take many forms. They might order one party to pay the other damages, enforce the terms of a contract, or issue an injunction prohibiting certain actions. It's like the final judgment in a court case, except it's usually issued much faster and with less fanfare. Now you might be thinking, John, what if I don't agree with the arbitrator's decision? Can I appeal it? Here's the catch. Appealing an arbitration award is much more difficult than appealing a court judgment. The grounds for appeal are very limited, and courts are generally reluctant to overturn an arbitrator's decision unless there's evidence of fraud, bias, or a clear violation of the law. Think of it like trying to return a sweater you bought on sale. It's possible, but it's going to be a lot harder than returning a full-priced item. Let us count the ways. Now that we've covered the basics of how arbitration works, you might be wondering, why would I choose this over a traditional court case? Well, my friend, let me enlighten you with the numerous advantages of arbitration. 1. Speed and efficiency. Forget those courtroom dramas where cases drag on for years. Arbitration is generally much faster than litigation, with cases often resolved in a matter of months rather than years. It's like choosing express delivery for your legal dispute. 2. Cost effectiveness. Let's face it, lawyers aren't cheap. Arbitration can be significantly less expensive than litigation with lower court fees, fewer discovery battles, and a quicker resolution. Think of it as finding a discount code for your legal fees. 3. Flexibility and control. Arbitration offers more flexibility than traditional litigation. Parties can choose an arbitrator with expertise in their specific field and can tailor the arbitration process to their needs. It's like designing your own legal dispute resolution menu. 4. Confidentiality. Unlike court cases, which are open to the public, arbitration proceedings are confidential. This can be especially beneficial for businesses dealing with sensitive information or individuals who value their privacy. Think of it as a legal dispute held behind closed doors, with no paparazzi allowed. These are just a few of the reasons why arbitration is becoming an increasingly popular alternative to traditional litigation. But remember, it's not a one-size-fits-all solution. It's essential to weigh the pros and cons carefully, and consult with an experienced attorney to determine if arbitration is the right choice for your particular situation. Like any legal process, arbitration has its fair share of myths and misconceptions. Let's debunk some of the most common ones, shall we? Myth number 1. Arbitration is only for big corporations. Reality. While it's true that corporations often include arbitration clauses in contracts, arbitration is available to anyone regardless of their size or financial resources. In fact, many consumer contracts now include arbitration clauses, so it's essential to be aware of your rights. Myth number 2. Arbitration is always unfair to the little guy. Reality. While there have been cases where arbitration has been used to silence victims or give corporations an unfair advantage, this isn't always the case. The fairness of arbitration depends on various factors, including the chosen arbitrator, the rules governing the process, and the party's willingness to participate in good faith. Myth number 3. You have no rights in arbitration. Reality. You still have rights in arbitration just like you do in court. You have the right to be represented by an attorney, present evidence, and cross-examine witnesses. However, the rules of evidence and procedure are typically more relaxed in arbitration, which can work in your favor or against you depending on the circumstances. Remember, knowledge is power. By understanding how arbitration works and separating fact from fiction, you can make informed decisions about your legal options and protect your rights. So there you have it, folks, a crash course in the wild world of arbitration. It's not as glamorous as a courtroom showdown on Law & Order, but it can be a surprisingly effective way to resolve disputes without the drama, expense, and time commitment of traditional litigation. But remember, this is just the tip of the iceberg. There's a whole lot more to learn about arbitration, from the different types of arbitration clauses to the intricacies of international commercial arbitration. So, I encourage you to do your own research, ask questions, and become an informed citizen when it comes to your legal rights and options. And hey, while you're at it, why not share your own experiences with arbitration? Have you ever used it to resolve a dispute? Did it work out in your favor? Let's keep the conversation going and shed some light on this often misunderstood area of the law. After all, knowledge is power, and the more we know about our legal options, the better equipped we'll be to navigate the complexities of life's inevitable disputes.